Okay, I'd like at this point in time to call the meeting to order. I want to extend to everyone here a welcome. Bienvenue à tous. Colleagues, this meeting is called pursuant to the standing orders, and today we have with us Deputy Commissioner Barbara George from the Royal Canadian Mounted Police, and she's accompanied by her lawyer, Mr. Jack Hughes. Mr. Hughes, Mrs. George, welcome to the committee. And as everyone is aware, this meeting, I don't think it'll be a long meeting, has been called to examine potential alleged indiscrepancies in the testimony of Mrs. George when she first appeared before this committee in February 21st this year. So I'm just going to make a prepared statement, and we're going to then ask Mrs. George to reply to the statement, and we'll take it from there. Ms. George, the committee has called you back because it feels you were untruthful in your testimony before this committee under oath on February 21st, 2007. In particular, the committee's concerns relate to the following testimony given on that date. Committee member, did you or Mr. Zaccardelli order that Staff Sergeant Frizzell be removed, or was it you or Mr. Zaccardelli who ordered that the investigation be shut down? Your answer, I can state with absolute, excuse me, gentlemen. Oops. Just sorry about that interruption. Your answer, I can state with absolute finality that it was neither the Commissioner Zaccardelli or myself, nor myself, that had anything whatsoever to do with, as you say, the removal of Sergeant Frizzell. Committee member, can you tell us who it was? Your answer to that question, no, I'm not aware of who it was. The best I can state that I understood that when Sergeant Frizzell left is that he returned to his home division, which was A division. I understood it was for health concerns. The committee is particularly concerned in your case, Mrs. George, as you are a senior uniformed member of the Royal Canadian Mounted Police, and, as such, a professional in the field of conducting investigations, gathering evidence, and weighing testimony. You were and are an important witness in the committee's inquiry into the alleged improper use of RCMP pension and insurance plan funds. As Deputy Commissioner of the Royal Canadian Mounted Police responsible for human resources, you had a central role in the matter under investigation by the committee. There was every reason for committee members to see your testimony as critical to establishing what took place, and you ought to have known this. In this case, the testimony sought related to a specific situation, namely, the manner by which Sergeant Frizzell was removed from the investigation being conducted into the alleged improper use of RCMP pension and insurance plan funds to meet administrative costs. You would know, Mrs. George, that sworn testimony can be based on either the personal knowledge of the witness as to the relevant facts or the honest belief of the witness where the witness has information on which to base this belief. This is often referred to as testimony based on information and belief. This is an important consideration with respect to your testimony, Ms. George. As a police officer trained in conducting investigations, gathering evidence, and weighing testimony, you must be familiar with those words, information and belief. The courts accept affidavits based on information and belief. In your testimony before this committee on February 21st, you used the expression, to the best of my knowledge, and prefaced the response with, I believe. And at one point said, as far as I know, and I believe to be this so. In your testimony on April 30th, in a lengthy answer to the same questions posed on February 21st about the removal of Staff Sergeant Frizzell, you described the events leading up to the removal and explained why it would have been either Assistant Commissioner Gork or Inspector Roy who caused the removal. You shared this with the committee on April 30th, but for some reason you couldn't share this with the committee on February 21st. Of course, our question is why. As well, Mrs. George, you had two meetings with staff prior to the February 21st appearance before this committee, and you were warned that the committee might ask you about the removal of Staff Sergeant Frizzell, and whether you caused his removal. Surely, in the course of these preparatory meetings, only a week or so ahead of your appearance before this committee, the circumstances surrounding the removal of Staff Sergeant Frizzell would have been reviewed and all possible questions to you by the committee considered. In your email of February 12, 2007 to a staff member about these preparatory meetings, you say, "Let's make sure the Q's and A's are as complete as possible." Despite this, when you appeared before the committee on February 21st and you were asked who, if it was not you, removed Staff Sergeant Frizzell, you said only that you did not know. In testimony before this committee on April 18, 2007, you testified that on June 20, 2005, which is the day that Staff Sergeant Frizzell was removed from the investigation, Chief Superintendent Lang told you that Staff Sergeant Frizzell had been removed on the orders of Assistant Commissioner Gork. 2 months later, you admit to having had knowledge on June 20, 2005, that you denied having when testified before this committee on February 21, 2007. The committee heard the testimony of Assistant Commissioner Rogerson on April 30th, in which he reviewed the events of June 2005, including his conversation with you by cell phone on June 16, 2005, where he says you indicated that you wanted Staff Sergeant Frizzell removed because he had left a phone message that you thought was harassing your staff. Assistant Commissioner Rogerson testified that he told you that you would need to talk to Assistant Commissioner Gork to get Staff Sergeant Frizzell removed. Assistant Commissioner Rogerson testified that he had first-hand knowledge of what was done and said that the removal related to your harassment allegation against Staff Sergeant Frizzell. Assistant Commissioner Rogerson, in his testimony, showed that Chief Superintendent Lang and Superintendent Newman agreed with him that you were involved in the removal of Staff Sergeant Frizzell. Assistant Commissioner Rogerson also showed that you knew exactly who served the removal order on Staff Sergeant Frizzell. Assistant Commissioner Rogerson summarized his testimony on April 30th in the following terms, and I quote, "In summation, the aforementioned info is how I understood things to have been done. Deputy George was actively seeking Staff Sergeant Frizzell's removal because he was harassing one of her employees. Based upon what I've been aware of, this was accomplished through a direct liaison with both Assistant Commissioner David Gork and Superintendent Lang shortly after contacting me on June 16th. The fact remains that the formal removal of Frizzell commenced between June 15th and June 20th, 2005. Chief Superintendent Lang's actions were no doubt influenced by Deputy Commissioner George's direct and clear involvement in Frizzell's being served such an order. In this regard, as mentioned, he was contacted by her directly, along with others, during this exact time frame. He consulted with them on the order, he served the order, and, when executed, advised them when it was done, which showed that Deputy George also knew about the order and who served it. You appeared before the committee on April 30th alongside Assistant Commissioner Rogerson, if memory serves. Before Assistant Commissioner Rogerson gave his opening statement, you gave an opening statement in which you set out the email exchanges that showed how you came to believe that Staff Sergeant Frizzell was removed for health reasons, which is what you told the committee on February 21st. You said that you did not order the removal of Staff Sergeant Frizzell. Admittedly, this is how the question on February 21st was phrased, whether or not you ordered the removal, but you answered in much broader terms, that you had nothing whatsoever to do with the removal. Your answer on February 21st was unequivocal and unlimited. By April 30th, particularly after the testimony of Assistant Commissioner Rogerson, it was not simply a matter of who ordered the removal, but whether you had any involvement in events leading up to the issuance of this order. You had an opportunity to testify more fully in your opening statement about your involvement in the removal of Staff Sergeant Frizzell, but you did not do so. It is only after having heard Assistant Commissioner Rogerson's testimony, in which he clearly implicates you in the removal of Staff Sergeant Frizzell, that you respond more fully to the question that was first put to you by a committee member on February 21st about the removal of Staff Sergeant Frizzell. Your response is that you only asked that Staff Sergeant Frizzell's harassing behavior be stopped, not that he be removed. Eventually, when pressed once again by a committee member whether you requested removal, you answered, "I cannot give you a yes or no answer." This was 2 years ago. The committee took this response as indicating an inability to recall the events of 2 years earlier. You admitted to speaking with Assistant Commissioner Rogerson, to Assistant Commissioner LaFosse, and to Chief Superintendent Lang, and they recall that you asked for removal. Why is it you can't remember these events in 2005, but these other officers can remember? In other testimony on April 30th, you recalled a meeting in 2001 quite vividly. So, Ms. George, the truthfulness of your February 21st testimony, that you didn't know who removed Staff Sergeant Frizzell, is hard for this committee to accept in view of the other testimony and evidence before the committee in respect of the events of the period June 15th to June 20th, 2005, including the evidence that you were very unhappy with the manner in which Staff Sergeant Frizzell was conducting his investigation, that you wanted something done about this, and that when you learned that he had been removed, you were grateful for the quick action taken against Staff Sergeant Frizzell. Ms. George, with the foregoing in mind, you might understand why members of this committee feel that your testimony before this committee on February 21st, you were less than truthful, and that you knew you were being less than truthful in your testimony. The committee is particularly concerned that false or misleading testimony would be given by a senior uniformed member of that cherished Canadian institution, the Royal Canadian Mounted Police. In the circumstances, Mrs. George, how can we believe that when you deny, as you did on February 21st, with absolute finality, to use your words, that you had anything whatsoever to do with the removal of Staff Sergeant Frizzell? And I'm going to ask you now to respond to that statement, Ms. George.
Mr. Chairman, on November 28, 2007, I received a letter from this committee inviting me to appear here today to address concerns members had about testimony I had given on February 21, 2007. The letter stated that I was being given an opportunity to explain my testimony and provide a full and unequivocal response to any concerns.
I really hesitate to interrupt you, and I apologize for doing so, but the interpreters here would have a difficulty translating your statement at that rate. So I will ask you to, we do have lots of time, I'll just ask you to slow your speech down somewhat.
Thank you.
And I apologize for interrupting.
That's okay. Thank you. The letter stated that I had been given an opportunity to explain my testimony and provide a full and unequivocal response to any concerns that might exist. The spirit of the letter, as well as other informal assurances given, clearly suggested that the committee would not make any final conclusions in respect of this matter until I had an opportunity to speak here today. I believe that the committee's invitation was being made in good faith and in the interest of procedural fairness. The facts now suggest otherwise. Late yesterday, less than 18 hours ago, the committee tabled its final report with respect to the RCMP pension and insurance plans. I admit that I was concerned with when the tabling of the report was only scheduled after I had committed to being here today, and my suspicions were not unfounded. The report contained a recommendation that the House of Commons denounce my behavior as someone who had tarnished the reputation of the RCMP through negligence, partiality, or dishonesty. Inexplicably, this recommendation comes in the middle of a section that does not even mention me by name. In fact, the report, which spans some 100 pages, does not even include any specific allegation of wrongdoing on my part. The report does not conclude that I was negligent. The report does not conclude that I was partial. The report does not conclude that I was dishonest. Yet, the report specifically calls on the House to denounce me for one or more of these alleged sins. Worse still, the recommendation in question groups my name with those of Jimmy Wanovich and Dominic Krupe. This is grossly unfair. I have never been accused of mismanaging pension or insurance funds. I have never been accused of accepting golf or hockey tickets. I have never been accused of hiring family members. I have never been accused of improperly awarding government contracts. The committee, by its actions, has forced me to conclude it isn't truly interested in what I have to say today. Still, I have honored my commitment to be here in the hopes that fair-minded Canadians have an opportunity to hear both sides of this story. For more than 8 months, my family and I have fought to clear my name and restore my reputation. I do so again now. Mr. Chairman, this is the 4th time that I have appeared before the Public Accounts Committee in respect of the RCMP pension and insurance matter. My first appearance was on February 21st and was subsequently followed by appearances on April 18th and April 30th. In total, I have appeared before this committee for more than 6 hours of questioning. Throughout the course of these hearings, like members of the committee, I have learned a great deal about what took place between June 2003 and June 2005. When I appeared here on February 21st, there were aspects of this investigation that I had no prior knowledge about, and on more than one occasion since, I was surprised by what I heard. The purpose of my appearance here today is to address concerns that committee members may have about the first 2 answers I ever gave this committee. To that end, I would like to put that first appearance and those first answers in their proper context. Ostensibly, the meeting on February 21st was arranged to discuss the Auditor General's report of November 2006 into the RCMP pension and insurance plans. I was asked to appear because Interim Commissioner Beverly Busson had only recently succeeded Commissioner Zaccardelli and had no personal knowledge of the events in question. As a member of the RCMP Senior Executive Committee and Deputy Commissioner Human Resources, I had expected to field questions on our response to the Auditor General's report. In fact, the events in question had transpired under the direction of my predecessor, Jim Ivanovich, and a particular director, Dominic Krupi, whose actions, amongst others, were the focus of the Ottawa Police Service investigation and the Auditor General's report. I was therefore prepared to answer questions about the procedures we had put in place to ensure that the management and misconduct she had found were never allowed to happen again. And, Mr. Chairman, those are what the questions and answers were specifically focused on. To be clear, however, the Auditor General's report of November 2006 did not mention Sergeant Mike Frizzell, nor did it discuss any allegations that an RCMP investigator had been improperly removed from the investigation. Consequently, Mr. Reznicki's first question to me about whether I had ordered the removal of Sergeant Frizzell was totally and completely unexpected, a proverbial bolt from the blue. Nevertheless, I answered the question as best I could, based on my personal recollection of the events at the time. The answers I gave were honest and accurate, as I did not order, nor did I have any desire to have Sergeant Frizzell removed from the OPS investigation some 15 months into their investigative work. Members of the committee will recall the testimony of retired Staff Sergeant Ron Lewis, who confirmed that I had played an important role in having the investigation started back in early 2004. There was never any intention to mislead or misinform the committee, and to this day, Mr. Chairman, I insist that I did not. The events surrounding the conclusion of the OPS investigation and the written order delivered by Chief Superintendent Doug Lang had occurred more than a year and a half before my first appearance. Despite the elapsed time, I answered all questions to the best of my recollection, and I stand by my answers again today. My memory of these events had not been refreshed by any personal notes or conversations with others, and I had not reviewed any documents or emails from that period before my appearance here. When the issue was brought up that I might be questioned on Sergeant Frizzell's removal, I absolutely dismissed it as saying I had nothing to do with this. So my Q's and A's were focused on Chapter 9 of the Auditor General's report. All I knew was that I had not ordered anyone to remove Sergeant Frizzell from the OPS investigation, and I recalled that he had gone on a period of sick leave around that time. Those 2 facts, which have been supported and confirmed by subsequent testimony and evidence, formed the basis of my response to Mr. Reznicki. It is important to note that at the conclusion of the February 21st hearing, while still in the committee room, Mr. Reznicki came to shake my hand. At that time, I offered to meet with him to discuss anything he was unclear as best I could. He acknowledged that this would be a good idea, but as it turned out, my office could never set a time with Mr. Reznicki's office. Mr. Chairman, another fact that must be explained is that prior to our appearance on February 21st, I had met with RCMP Legal Services to confirm what I could and could not discuss as a witness before this committee. It was my first experience as a witness before a parliamentary committee, and I was unfamiliar with both the process and the concept of parliamentary privilege. RCMP Legal Services advised that while parliamentary privilege would cover much of our testimony, we had to remain mindful of the proper application of the Privacy Act. While we could discuss our work and ourselves, we were to be cautious about making comments on the personal details of other RCMP members or officers. Indeed, if you look at the transcript from the meeting of February 21st, you will note that I and other witnesses cited privacy concerns and the Privacy Act in the course of our testimony. Whether or not you agree with that interpretation of the Privacy Act, the effect of that advice was that I was both careful and cautious in discussing anything that dealt with other RCMP officers or members. While this did not change the answers I gave that day, it limited the extent to which I was able to volunteer additional information beyond what was asked of me. I mention this because my answer to Mr. Wisniewski's second question specifically addressed privacy concerns, and because I think it is important for the committee to fully appreciate my state of mind on that day. Mr. Chairman, later in my first appearance, I was asked by Mr. Wisniewski whether Assistant Commissioner David Gork had ordered the removal of Sergeant Frizzell. As I wasn't entirely certain and did not want to mislead the committee, I said that I could only speculate if he wanted me to do so. At that point, Mr. Chairman, you intervened, and I quote, "If I can interrupt, Mr. Wisniewski, I don't want anyone to speculate at this hearing." Had I been allowed to answer, had I been allowed to speculate, I would have said that it would have likely been Assistant Commissioner Gork or Inspector Roy. In fact, if you look at the transcript for the meeting of April 30th, you will see me testify to that effect in response to a question from Mr. Sweet. As it turned out, I was only able to verify the relevant information and give a more detailed answer on April 18th, after I had already been accused of perjuring myself. In subsequent appearances before this committee, members, including Mr. Williams, have asked me why I did not volunteer the fact that I had spoken with other officers about Sergeant Frizzell. I can honestly say that they did not come to mind in those first moments on February 21st, and I did not immediately appreciate their connection to Mr. Wisniewski's question. All I could do, and all I did, was answer the question as it was put to me. In my defense, however, once that link had been made, I provided full details of those calls at my next appearance on April 18th, along with several emails and other supporting documents. For these reasons, in considering if I had misled this committee, it is absolutely critical that you consider all 6 hours of my testimony and not merely the first 6 minutes. Mr. Chairman, in its report yesterday, the committee indicated that one issue left unresolved was whether Sergeant Frizzell was removed from the OPS investigation or was merely sent back to his home unit because the investigation was over. I would like to offer now what I believe is the best summary version of what took place in June 2005. In so doing, I am relying on both the oral testimony before this committee and the documentary exhibits tabled by witnesses. I will also refer to the sworn statements that were given to Chief Superintendent Bob Paulson and his team in the course of his Code of Conduct investigation. These interviews form the heart of the so-called Paulson Report, which was tabled with this committee by Commissioner Busson in mid-May 2007. The sworn statements in question were appended to the report as Appendix C. It is my understanding that due to a lack of translation resources, these interviews were never translated and therefore never distributed to members of this committee. While I respect that the committee may have felt it had no choice in the matter, I believe it was a mistake for the committee to conclude its review of this matter without having read those sworn statements. The statements often provide additional detail and clarification of matters that had been discussed in this committee, and I believe that they would have been of tremendous value to you in your inquiries. As you know, I was suspended from my duties for a period of 8 months, starting back in March 30th, 2007. During my suspension, I had ample time to read and review these documents. Accordingly, I believe that I now have a much better and more complete understanding of what happened to Sergeant Frizzell in June 2005. On May 30th, 2005, at 9:11 a.m., Inspector Roy wrote an email to his investigative team, which included Sergeant Frizzell, which read in part as follows. First, the interview phase is over and we need to move on. This simply means that no more interviews will take place until I direct so. We have 2 weeks to put the investigative report together, and I want the draft in my hands at the latest on June 10th. On June 7th, end of quote. On June 7, 2005, Inspector Roy received a call from Rosalie Burton, who complained about the behavior of Sergeant Frizzell and said that he had requested a meeting with her on June 17, 2005. Inspector Roy's notes from that day, which were tabled with this committee, show that he told Ms. Burton that Frizzell was doing this on his own and not as a representative of the OPS investigation. Later that same day, Inspector Roy met with Sergeant Frizzell and suggested that if he had ongoing concerns, he should state as much in his portion of the investigation report, and it would be communicated by the OPS when the report was given to Commissioner Zaccardelli. As Inspector Roy has noted here, for reasons that are unclear, Sergeant Frizzell did not include any reference to these concerns in his final investigative report. A few days later, on or about June 13, 2005, Rosalie Burton complained to me, as she had to Inspector Roy, about Sergeant Frizzell's behavior. On June 15, 2005, I called Assistant Commissioner Darrell LaFosse. As he has testified here, his total contact with me on this matter did not last longer than 1 minute. I conveyed to him my concerns relating to what I had been told about Sergeant Frizzell's behavior, but he quickly advised me that he was no longer responsible for him and that I should call Assistant Commissioner Bruce Rogerson. As he later testified, once he pointed me in the right direction to the appropriate supervisor, he completely dismissed my telephone call. Moreover, in his interview with Chief Superintendent Paulson on April 10, 2007, Assistant Commissioner Foss stated in 6 separate answers that he could not and he would not say that I had asked him to remove Sergeant Frizzell. As an example, on page 15 of the interview transcript, Assistant Commissioner LaFosse said, quote, "She wanted something done with Mike Frizzell, but specifically saying, I want Mike removed. I can't say she said that. I really can't." On page 28, he says, quote, "She was upset. She was of raised voice, but she was agitated about the actions of Mike Frizzell. No question. There was no gray area in that whatsoever. As far as specifics, Darrell, I want you to remove Mike Frizzell. I can't say that. I could not say what was the end result was that she wanted, but she wanted it." On June 16th, further to Assistant Commissioner LaFosse's suggestion, I got in contact with Assistant Commissioner Rogerson, who was in his car on his way back from Montebello. It was his testimony and evidence that our call also lasted less than a minute. In fact, his cell phone records show that the call lasted a mere 50 seconds. Assistant Commissioner Rogerson and I disagree as to the exact words spoken during that call, but there is no dispute that he informed me that Frizzell did not report to him and that I should speak with Assistant Commissioner Gork. Assistant Commissioner Rogerson later confirmed the substance of our conversation in an email to me at 2:04 p.m. that same afternoon. In part, it read as follows. "Just to reiterate my comments, I have purposely avoided any contact with the investigators in relation to their work. In this regard, they are still under Assistant Commissioner Gork's direction." He then added, and I quote, "Having said this, if there is anything you would like for me to do to correct such behavior, I will assist from that aspect." That email, which has been tabled with this committee, suggests that Assistant Commissioner Rogerson understood that we were talking about correcting behavior, not removing an investigator. Later, on June 16th, I contacted Chief Superintendent Doug Lang, as I knew that he was acting in place of Assistant Commissioner Gork, who was by then serving in Lyon, France. As I had with both LaFosse and Rogerson, I advised Chief Superintendent Lang that I had received complaints about Sergeant Frizzell's behavior. It is his evidence and testimony that I asked him to address the matter with Inspector Roy. He has further given evidence that at no time did the words come out of my mouth that Frizzell had to cease and desist. Lang has said that I did not give him any direction on what had to be done, nor that Frizzell had to be immediately taken off the investigation. I now know that Chief Superintendent Lang went to see Inspector Roy that same day. Lang has told investigators that Inspector Roy was already aware of the allegations that Frizzell was continuing to take investigative steps by trying to interview people and doing things he had already been told not to do. Inspector Roy further advised Chief Superintendent Lang that he had been having problems with Sergeant Frizzell during the investigation, all related to his adherence to direction. Inspector Roy and Chief Superintendent Lang then discussed what needed to be done. They determined, according to Lang, that enough was enough, but they did not come up with the decision to serve him with the order. That same day, June 16th, sometime shortly after his meeting with Inspector Roy, Chief Superintendent Lang received a call from Assistant Commissioner Gork. Lang has explained that he believed and understood that Gork and Roy had spoken by that point, and it was during that call that Gork directed Lang to serve Frizzell with a written order. To be clear, I had not spoken to either Inspector Roy or Assistant Commissioner Gork about the complaints I had received with respect to Sergeant Frizzell's behavior. Following his call with Assistant Commissioner Gork, Chief Superintendent Lang prepared a draft written order to serve on Sergeant Frizzell. As Chief Superintendent Lang has testified, I did not assist him with the drafting of the order. Indeed, I do not believe that I ever spoke with him again until after he had served the order on Frizzell on June 20th, 2005. Chief Superintendent Lang's further evidence is that the order was completed on the afternoon of June 17th, and that they would have served it on Sergeant Frizzell then, and I believe they did try to serve it, but Sergeant Frizzell had already left for the weekend. In a separate interview with the Paulson investigative team, Sergeant Frizzell confirms this by saying that he had left halfway through the day on June 17th to go on a field trip with one of his children. The committee must recognize the following critical points. Inspector Roy gave his final report to Chief Bevan of the Ottawa Police on June 17th. The report submitted by Inspector Roy included a final report from Sergeant Frizzell, which had been given by Frizzell to Roy at approximately noon that day. As a result, we can say without any doubt that Frizzell was not served with the written order until after the final investigation report had been submitted. On Saturday, June 18th, I had a conversation with Assistant Commissioner Gork. When I mentioned to him the complaint of Ms. Burton regarding the alleged behavior of Frizzell, he told me that it was now a moot point as the investigation was over and all the investigators were being returned to their original positions. Let me repeat that. I did not speak with Assistant Commissioner Gork until after he had already directed Lang to serve Frizzell with a written order and after the final report had been given to Chief Bevan. On Monday morning, June 20th, I had a meeting scheduled with Sergeant Frizzell. Knowing what I had been told by Gork, I sent an email to Lang asking what was being done about Frizzell. Lang subsequently notified me, after the fact, that he had served the order on Frizzell and that Frizzell was going to speak with a doctor. I believe that this represents a fair synopsis of what took place during that crucial week in mid-June 2005. Members may ask themselves why this version of events was not fully articulated in April of this year when I last appeared as a witness. The reason is very simple. It was not until I had received and reviewed the sworn statements given by the relevant officers, as contained in the Paulson report, that I knew the full story. Prior to receiving the Paulson report in early July, I did not have detailed knowledge of the conversations that had taken place between Roy, Lang, and Gork. To that end, I did not have a complete understanding of the timeline of events that resulted in the written order having been served on Frizzell. I believe it is crucial that this committee draws the necessary distinction between what I knew on February 21st and what I know today. Like all members of this committee, I learned more details about what happened as this inquiry was ongoing. I simply could not have given the detailed testimony I have provided today back in February, as I did not have the detailed information. Mr. Chairman, in closing, I would like to address three other issues that I think are of considerable importance. First, I would like it to be said on record that despite the fact that several witnesses have given conflicting or even contradictory versions of events, I am the only one who has been called to explain myself. To cite just one example, I would point to the allegation made by Chief Superintendent Macaulay that I had told him that he was on an island and that people would not tell the truth about what happened. On March 28th, in response to a direct question from Mr. Christofferson, Chief Superintendent Macaulay testified that this was an exact quote based on notes he had taken at the time. However, when interviewed by members of the Paulson investigation team on April 3, 2007, Chief Superintendent Macaulay gave evidence that his notes were made a year after the event in question. The Paulson report into the Code of Conduct allegations also states that Chief Superintendent McCauley paraphrased my statement as he was unable to provide my exact words, which the investigators themselves noted was contrary to his exact quote reference during his March 28th committee appearance. As the committee itself noted in its report yesterday, it has heard conflicting and often contradictory evidence from many witnesses. This was as much a point of frustration for me as it was for the committee, and to that end I intend to pursue these matters through the appropriate channels in the days and weeks ahead. Mr. Chairman, my second point relates to the real reason I am here today. I believe that I have been unfairly singled out because of Mr. Wisniewski. From the first day that I appeared before you, Mr. Wisniewski has identified me as a target. He has, on at least 2 occasions, quoted documents grossly out of context in a manner that has painted me either as a liar or a thief. He has also repeatedly used the term perjury, despite having been asked not to do so in public sessions by both yourself, Mr. Chairman, and other members of the committee. This is particularly unacceptable given that the term perjury was seized upon and repeated in the media, notwithstanding that the appropriate term is contempt of Parliament. Mr. Wisniewski has been criticized by other members for hoarding documents in secret and then springing them on unsuspecting witnesses without having first shared them with other members on the committee. Mr. Wisniewski met with key witnesses like Chief Superintendent McCauley prior to their testimony to discuss allegations they were going to make and determine which would best hook the committee's interest. And finally, on at least 2 occasions, he was invited to recuse himself by another member for being in a clear conflict of interest. It goes without saying that Mr. Wisniewski and I have ongoing disputes that extend beyond the mandate of this committee, and I would ask that they be allowed to resolve themselves in the proper legal forum. Third and finally, Mr. Chairman, is the issue of parliamentary privilege. As you are aware, on March 30th, 2007, Interim Commissioner Busson initiated a formal Code of Conduct investigation into my actions. The main allegation was that I had misled this committee during my testimony on February 21st. A week later, on or about April 3rd, the investigating officer initiated a concurrent criminal investigation to determine whether I had violated Section 131 of the Criminal Code. I was forced to challenge these investigations in federal court, and ultimately the court declared portions of the Code of Conduct investigation to be unlawful. On May 2nd, 2007, the chair sent a letter to the commissioner asking her to confirm that no investigation was underway that relied on my testimony before this committee. The interim commissioner's response, sent on May 14th, did the opposite. Not only did it confirm that an investigation was ongoing, it suggested that it would continue as the law surrounding parliamentary privilege was unclear. Shortly thereafter, Chief Superintendent Paulson wrote to Speaker Milliken asking him to get the House of Commons to waive its privilege as it related to my testimony. In reply, Speaker Milliken wrote to Paulson and advised him that testimony before a committee could not be questioned outside of the committee, even by an agent of the Crown in the context of an investigation. Chief Superintendent Paulson did not terminate his investigation into my testimony until the House of Commons held a formal vote on the question in mid-June. In fact, just this past week, Chief Superintendent Paulson had to be ordered to return exhibits seized under warrant from my office. For 2.5 months, my testimony was being aggressively investigated by no fewer than 12 RCMP officers, all contrary to the doctrine of parliamentary privilege. I believe that this situation arose as a direct result of Interim Commissioner Busson's panicked reaction to the media frenzy caused when Mr. Wisniewski publicly accused me of perjury. It is my hope and belief that this will be my last appearance before this or any other standing committee. Yet the question of how and when a witness is protected when testifying before these committees remains an open question. If the House does not enforce its privileges, they will be slowly eroded to the detriment of the rule of law and our system of parliamentary democracy. Mr. Chairman, as troubled as our past history has been, I would like to thank all members of this committee for giving me this last opportunity to address your concerns. The RCMP is currently facing a very difficult time. The past few months, indeed the past year, have been a time of great sadness and tragedy within our force. Still, I am optimistic that our best days lie ahead under the direction of our two senior leaders, Commissioner Bill Elliott and Deputy Commissioner Bill Sweeney. These two individuals undertook to obtain all the facts of my situation. They looked at every perspective and motive before arriving at the conclusion that the right thing to do was to reinstate me and to permit me every opportunity to regain my good name in the face of seemingly irreparable damage done to my career and reputation. I am thankful for and I applaud their integrity and courage. Now, Mr. Chairman, I watched you on CBC News World last night, and I heard you say that I was not totally truthful in my testimony. And so I am prepared to stay here all day, if necessary, to discuss any concerns you may have.
Thank you very much, Mrs. George, and I want to thank you on behalf of all members of the committee for your appearance here today, and I want to also thank you, Mr. Hughes, for your assistance. Mr. George, your transcript of your entire proceedings will be translated, and it will be circulated to the members. The members will again be examining the entire record, including the Paulson report, and they will be deliberating on the matter, and they will be coming to a decision in due course. I know this issue is troubling to you, and it's troubling to the members of the committee also, and we do have inconsistencies in testimony. It is an issue that this committee does take very seriously, and following up with your comments on the privileges of the House, that is another issue that this committee takes very seriously and is prepared to defend, as it did in your case, the privileges of the House. So again, I want to thank you very much, and we will be making a decision and we will be getting back to you. Thank you. We have another witness, colleagues, but we'll suspend for 1 minute. Okay, members, I'd like to resume the meeting and welcome everyone back. And I want to welcome to the committee Commissioner William Elliott, the Commissioner of the Royal Canadian Mounted Police. Welcome, Commissioner Elliott, and thank you very much for your attendance here today on unreasonably short notice. And members, what the purpose of Mr. Elliott's appearance here today is, and it is restricted, and I do have instructions from the steering committee to restrict it. We're going to allow certain questions, but it's going to be restricted only to the reinstatement of Deputy Commissioner George, and that's the only issue we've asked Commissioner Elliott to appear, and that's the only issue that he will be questioned on here today. But before inviting Commissioner Elliott to make an opening remarks, one of the members has suggested that I table in both official languages the letter that was sent to Barbara George on November 27th, and that letter will be tabled with the committee and circulated to all members. And the clerk has indicated that it's being distributed right now. So, back to the business. Again, welcome, and Commissioner Elliott, if you haven't, I'd invite you to make your opening remarks now.
Merci, Monsieur le Président.
Thank you very much, Mr. Chair. I would like to begin by clearing up a little bit of confusion between my office and the clerk of this committee. I don't have a written statement.
Commenting or responding to the motion that's the subject of my appearance this morning, and then to try to respond to any questions. So, as I understand it, you're interested in knowing more about the reinstatement of Deputy Commissioner George, and I think in particular in relation to the timing of those events. And perhaps I could start by giving a brief chronology. I appreciate that some of what I'm about to say the committee is very familiar with, but I think it would be helpful just to set the context if I started back with the suspension of Deputy Commissioner George by the previous Commissioner of the Royal Canadian Mounted Police, Beverly Busson. That occurred, as I said, on March the 30th. There were 3 allegations made respecting Deputy Commissioner George, which were included in the formal notice of suspension. As part of the process for disciplinary hearings under the RCMP Act, an appropriate officer was appointed. That appropriate officer was Deputy Commissioner Bill Sweeney, who at the time was the Deputy Commissioner of the Northwest Region and the commanding officer of K Division, that is Alberta. Deputy Commissioner Sweeney, as you will know, is since transferred to Ottawa and is serving as a special advisor to me. On June the 21st, after having reviewed the results of an investigation launched with respect to the 3 allegations which I have mentioned, a notice of disciplinary hearing initiating the formal discipline process was issued. Between June and the fall, additional information was brought to the appropriate officer's attention. I understand that, among other things, Deputy Commissioner Sweeney had a number of discussions with parties in headquarters with information. Those included the officer in charge of the investigation, Chief Superintendent Bob Poulsen, the former Commissioner of the Royal Canadian Mounted Police, Beverly Busson, and legal counsel. Deputy Commissioner Sweeney subsequently informed me that he had determined that there were not grounds to proceed on the first and third allegations contained in the notice of suspension. The second allegation was related to Deputy Commissioner George's appearance before this committee, and I'm sure, Mr. President, you and your colleagues are familiar with the issues surrounding parliamentary privilege and the rulings by both the House of Commons and the federal court in that regard. On November the 19th, Deputy Commissioner Sweeney, as the appropriate officer, formally withdrew the allegations against Deputy Commissioner George. Those allegations were the basis for the suspension, and therefore on the 23rd of November I signed a notice of revocation of the suspension, and on the 28th of November I issued a statement to all of the employees of the Royal Canadian Mounted Police announcing that the Deputy Commissioner had been reinstated and that she would be returning to active duty on the 28th of November. I would be happy to entertain your questions, Mr. Chairman.
Thank you very much, Commissioner Elliott. I'm in the hands of the committee, but we could have one round of 5 minutes. That would be 5 minutes each. Does that sound reasonable? Okay. Mr. Rosniski, 5 minutes. And don't feel that you have to take 5 minutes. And again, I caution members, we're restricted only to the reinstatement. That's the only issue that Commissioner Elliott was invited here to talk about today, and that is all we're going to talk about. So, Mr. Rosniski.
Thank you, Chair. Commissioner, from day one in testimony before this committee on the RCMP, we've heard that there's an appearance, or in fact it's the case of no consequences for inappropriate actions at the top echelons of the RCMP. As you stated, there's a very detailed investigation by Chief Superintendent Polson that had three findings, recommendations that went to Deputy Commissioner Sweeney, and that's that Deputy Commissioner Barb George be charged with conduct unbecoming, misleading Commissioner Busson, and providing false testimony. Now, as a consequence of us not waiving parliamentary privilege and the court decision about parliamentary privilege, a number of those had to be withdrawn. Commissioner, you were aware that we were ongoing with our investigations, preparation of a report. Did you think that it would be appropriate to wait until such time that we had concluded?
Point of order. I'm concerned with the questioning, given that Parliament has explicitly told the RCMP that it cannot use any of the testimony or any of the proceedings that occur before this committee as consideration in its investigation of its own employees. Nothing that happens here can be used in proceedings out of this place. Yet Mr. Yasneski is now using what's happening here as the premise for a question over how the Commissioner here has addressed the issue of staffing within his agency. So I think that we're contradicting ourselves if we're going to invite the Commissioner here, ask him to explain why he's not listening to the testimony and the hearings that occur before this committee, when we've explicitly, through the Speaker, told him he cannot do so.
Thank you very much, Mr. Polyev. I've been listening very carefully to the question. Mr. Polyev is right that the law of parliamentary privilege would preclude the Commissioner and anyone in the RCMP from carrying out this, using the evidence given by Ms. George before this committee. However, they can use the decisions of the, if they so desire, of the committee in a report to the House. So I certainly find the question in order, but again, I reiterate that that the evidence given by any witness, including Deputy Commissioner George, is not to be part of an informal or a formal code of conduct proceeding or any other proceeding for that matter, and but the actual decision of the committee could be, if the authorities so choose, be taken into consideration and given whatever weight they deem necessary. Is that okay, Bob? Okay, and you're
just to respond to that as well before the clock starts. Thank you. And that's exactly the point that I was making, Mr. Poilievre. That's why I reiterated that parliamentary privilege prevented these proceedings from going forward. My question was a question of caution, knowing that there was an imminent report that would come out with recommendations, whether or not the Commissioner felt that it was impossible to wait until recommendations came out of this committee.
Thank you, Mr. Chairman. As I indicated, when I became Commissioner of the Royal Canadian Mounted Police, a formal process had already begun, and that process was based on 3 specific allegations. As we have noted, the second of those 3 allegations was beyond the purview of the investigation and the process following actions taken by this committee and the House of Commons, and as confirmed by the federal court. And maybe I could just refer to the decision of the Honourable Madam Justice Tremblay-Lemaire, dated May the 29th, 2007, where the Justice says in the closing comments of the judgment, the RCMP is free to investigate allegations that the applicant breached the RCMP Code of Conduct in the discharge of her duties, but may not investigate the specific allegation that the applicant provided false testimony to the House. Parliamentary privilege protects what is said in the House, and if the House believes it was misled, it is for the House alone to investigate and punish the offence. Therefore, I did not think that it was necessary or appropriate to wait for the committee's report with respect to an allegation which we were no longer advancing and which we were no longer investigating. And with respect to the other 2 allegations, the decision by the appropriate officer, Deputy Commissioner Bill Sweeney, was that there were not sufficient grounds to proceed to an adjudication. I therefore had no reasonable basis not to reinstate the Deputy Commissioner. As I have said on other occasions, I am the Commissioner of the RCMP. I and the RCMP believe in due process. Due process was followed in this case. As soon as I was notified that the appropriate officer intended to withdraw the allegations, I instituted the process to reinstate Deputy Commissioner George. I believe it was the only reasonable and honourable thing for me to do.
Very short question, 30 seconds, Mr. Rosenstein.
What were the terms of settlement? Is she fully reinstated?
There were no...
Point of order.
Point of order?
I don't think that we need to get into settlement agreements that other organizations reach with people. I don't know if that's an appropriate question. Perhaps you could ask the law clerk.
Obviously, it's relevant to the line of questions that the committee wants to look into, but as you know, sometimes committees are concerned about privacy rights, and the employer-employee relationship between is by nature private in some respects, but in other respects it's quite public, particularly here where it's a public institution, and the status of this individual in that institution as an employee has been very much in question, particularly the reinstatement to full employment. It's understandable that the committee might be interested in knowing whether there were any conditions attached to that reinstatement, but I think points about privacy might be kept in mind.
The question's in order, so go ahead, sir.
Thank you, Mr. Chairman. There was no agreement with respect to the reinstatement. I and others indicated to the Deputy Commissioner that she would be reinstated. I informed the Deputy Commissioner that I would not be reassigning her to the position of Deputy Commissioner of Human Resources and Chief Human Resources Officer. We had discussions about her return to duty. We did agree on a start date, but there were no other agreements made with respect to the reinstatement.
Thank you, Commissioner Sweeney. Monsieur Laforêt, jusqu'à 5 minutes, s'il vous plaît.
5 minutes, Mr. Laforêt. Thank you, Mr. Chair. Mr. Elliott, I would like to discuss certain questions. You said that Ms. George was reinstated. She went back to work following a recommendation by a Deputy Commissioner who had led an inquiry into the matter. Did you yourself undertake an evaluation of the situation before accepting the recommendation made by a Deputy Commissioner? Are you yourself clearing her completely by this gesture of reinstating her? Because you have a certain responsibility in this area, because Ms. George has been subject to criticism. She said that she wasn't aware of all the facts at the time. And so then if she wasn't to blame, is there not a blame in terms of her lack of being awareness, a lack of the necessary skills, as it were? Answer. I would like to clarify one important point, please, Mr. Chair. Deputy Commissioner Sweeney did not make a recommendation.
Pursuant to the code, appointed as the appropriate officer, it is up to the appropriate officer to make a determination with respect to whether to proceed or to not proceed. And the federal court, I would point out in its decision, also in addressing questions of procedural fairness, underscored that the commissioner, in that case, she was the court was speaking of my predecessor, but the reference certainly applies to me as commissioner as well. The commissioner does not make the determination as to whether or not someone is guilty or not guilty, or whether there is a case to be made for adjudication. Deputy Commissioner Sweeney did not make a recommendation to me. Deputy Commissioner Sweeney conveyed his decision to me, and I took action pursuant to that decision.
Okay. Vous dites donc que c'est pas vous qui...
You are saying then that even as a commissioner, you didn't have to make a decision. It was the Deputy Commissioner who was responsible for this inquiry? Is that what you're saying?
Deputy Commissioner Sweeney was appointed the appropriate officer, which is the process followed when a formal discipline process is initiated under the RCMP Act. He made a determination with respect to, based on his evaluation of the evidence, as to whether there were sufficient grounds to proceed to adjudication, and in his opinion, there were not sufficient grounds to proceed, and therefore he withdrew the allegations. My role then was to deal with the consequences of the fact that there was no longer a disciplinary process pending, and to reinstate Deputy Commissioner George. I made a number of decisions in relation to that, including, frankly, the question of reinstatement was not a terribly difficult one, because the basis on which the suspension had been made were no longer in existence. The question for me really was whether or not she would go back to her previous position as the Deputy Commissioner for Human Resources.
Et elle est revenue sur quel poste exactement?
What job, which position did she go back to? Could you tell us exactly which job she went back to? Perhaps you've already said that. But I believed you had said that Mr. Sweeney made a recommendation, but you're saying it wasn't a recommendation. I just thought earlier you'd used the term recommendation, but perhaps not. And which position did she go back to when she was reinstated?
The Deputy Commissioner is doing or will be doing a number of projects pending the start of educational leave, which was agreed to in an agreement entered into by Commissioner Bussin on the 27th of March 2007.
Thank you, Mr. Elliott. Merci beaucoup, Mr. Laforêt. Mr. Williams.
Thank you, Mr. Elliott. Thank you, Mr. Laforêt.
Thank you, Mr. Chairman. Mr. Elliott, Ms. George told us that you looked into all information before you reinstated her, and actually you quoted a text from the court decision regarding the testimony before this House that said that the RCMP had no capacity to pursue the matter of the evidence given under parliamentary privilege. Now, I understand that you have reinstated Ms. George, but I'm rather concerned that you would reinstate the Deputy Commissioner of the RCMP when, in your words, you said there was no disciplinary process pending. Well, I beg to differ because there is a disciplinary process pending. It's going on right here this morning, Mr. Elliott, where we had Ms. George defending herself on her statements. And I'm concerned that you reinstated someone of that rank in the RCMP when she was under a disciplinary process of another venue, and I agree another venue, even though it was outside your purview, it was within our purview to have a disciplinary process, and I want to know why you reinstated her when we were still looking into a matter that Chief Superintendent Paulson referred to as perjury. Now, that's a serious allegation in a parliament, as Ms. George pointed out, we call it contempt of parliament. But it's the same seriousness of a charge, and given that that was hanging over her, why would you reinstate her at that time?
Thank you, Mr. Chairman. I would like to clarify that in my response of referring to there being no discipline process, I was referring to matters within my purview and the purview of the RCMP, and that is disciplinary procedures pursuant to the RCMP Act. In answer to the honourable member's question, I refer again to the decision of the federal court, which in essence directs me as Commissioner, and I quote again, if the House believes it was misled, it is for the House alone to investigate and punish this offence. I do not believe that the fact that this committee and the House still have issues before it can be used by me with respect to a disciplinary matter under the RCMP Code of Conduct.
Well, I'm not talking about the RCMP Code of Conduct, Mr. Chair. We're talking about the reinstatement of Barbara George at that particular time, given the fact that there was a serious disciplinary process in place and ongoing at that time. Now, I think what the Commissioner is trying to tell me, Mr. Chairman, and he can correct me if I'm wrong, that a senior member of the RCMP could be under a cloud of accusation in any other venue outside the RCMP, and it means nothing to the RCMP, even for deputy commissioners, that they can continue on working and so on with no appropriation of any kind because it's in another venue. This is a serious charge hanging over Ms. George. She realizes that. I would hope that the RCMP and the Commissioner realizes that. And therefore, my concern is for the 26,000 Canadian RCMP officers who are putting their lives on the line to uphold the law, and we have lost far too many of them over the last few years, that we would have a deputy commissioner who is under a cloud of contempt of Parliament, potential contempt of Parliament, which Chief Superintendent Paulson referred to as perjury, and yet the Commissioner reinstates her as a Deputy Commissioner, even with that allegation hanging over her head. And that's why I want to know what the Commissioner is doing at this point in time. Why didn't he wait until this committee resolved whether or not it believed there was a contempt of Parliament or that she had misled the committee, and then he would have been free to make his decision?
Chairman, I believe I have been directed by the court and by Parliament not to deal with the question of contempt. I again refer to the judgment of the federal court at paragraph 65. Finally, if Parliament has reason to believe that a witness has deliberately misled the House, it is up to Parliament and Parliament alone to initiate proceedings and discipline such conduct. Misleading the House is contempt of the House, punishable by the House. If a court or another entity was allowed to inquire into whether a member or a witness had misled the House, this could lead to exactly the type of conflict between two spheres of government that the wider principle of parliamentary privilege is designed to avoid.
Therefore, Mr. Chairman, what he is telling us is that if we find contempt of Parliament akin to perjury, it means nothing to RCMP and she can continue on in her position. Is that what he's telling us?
Clarify you just briefly, Mr. Williams. It won't be us; it'll be the House in the contempt. It's a minor point, but
if this committee finds that the allegations are upheld, it means nothing to a career of the senior member of the RCMP. Where are we going from here if we find the allegations are upheld?
Well, Mr. Chairman, I don't think that it would be appropriate for me to speculate, but if and when matters unfold, we will consider those matters and consider what, if any, further action is warranted.
Just one point I want to make before we go to Mr. Christopherson and Commissioner Elliott. I want to clarify. You're quite right. And you're quite right in quoting the court case about the parliamentary privilege, about the evidence of Deputy Commissioner George before that could not be used by the RCMP in their code of conduct investigation. But there's all kinds of allegations in the Paulson report, and that is your report. That's not. You certainly are entitled to look at that, look at the allegations, and give it whatever weight you think it deems necessary in coming to your decision. So did you consider that report, or are you confused that you can't consider those allegations also?
Thank you, Mr. Chairman. First of all, I'd just like to clarify, if in your question, when you use the term you, if you mean the RCMP, then I certainly agree with you. But I do think that it's important to be clear as well with respect to which officer of the RCMP played which specific role in all of this. Chief Superintendent Paulson conducted an investigation. He initiated investigations into all three allegations. The investigations continued into allegations number 1 and allegations number 3, and if it would help, I can refer you specifically to those allegations. It was on those allegations that he reported to the appropriate officer, Deputy Commissioner Sweeney, and it was with respect to those allegations, having reviewed the results of the investigation and other information, that Deputy Commissioner Sweeney, the appropriate officer, determined that there were insufficient grounds to proceed to adjudication.
Mr. Christopherson, 5 minutes, up to 5 minutes.
Thank you, Chair, and thank you, Commissioner, for attending today. I would benefit from being reminded of those 3 allegations, if you would, very briefly, please. Just the essence of them.
The first is that on or about September 19th, you did conduct yourself, and this was addressed to Deputy Commissioner George, in a disgraceful manner that could bring discredit on the force. During a meeting with Chief Superintendent Fraser McCauley, you advised him that he was on an island by himself and that others would not tell the truth. You explained that Chief Superintendent McCauley was naive to think anyone would stand beside him in this type of situation. This is contrary to subsection 39(1) of the Royal Canadian Police Regulations 1988. And number 3, that between February 21st, 2007 and March 28th, 2007, you did conduct yourself in a disgraceful manner that could bring discredit on the force, and that knowing that you had been involved directly or indirectly in Staff Sergeant Mike Frizzell's removal, and knowing that I had taken as Commissioner of the RCMP, that's Commissioner Buston speaking, to provide the Standing Committee on Public Accounts with all of the information pertaining to Staff Sergeant Frizzell's removal, you failed to inform me, your superior officer, of the above. Failing to disclose the extent of your involvement has resulted in an incomplete response being provided to the committee. This failure to disclose your involvement is contrary to subsection 39(1) of the Royal Canadian Mounted Police Regulations 1988.
Thank you. And the second one pertained to the actual testimony that was here that the court removed. Was that too?
That's correct.
That's correct.
By giving the allegation refers to giving false testimony before the Standing Committee on Public Accounts on February 21st, 2007.
So that one was already by the courts ruled out of your purview, and you were left with 1 and 3.
Yes.
Could I ask the law clerk, Chair, if I might have? No, that's fine. If I might have the attention of the law clerk. Okay. Mr. Question to you, sir. Yes. You've heard the answer. I just need some legal advice as to where the interface is. I understand the responsibility that we have in terms of what we're looking at. I'm hearing the Commissioner talking about the allegations 1 and 3 that were left that he had to, and the RCMP had to come to grips with. They are the same matters that we're dealing with, but it's within the RCMP, those allegations, not necessarily what's come here. I'm just having some trouble understanding the interface between our role and that of the Commissioner vis-a-vis allegations 1 and 3. Can you provide me with some guidance, please?
Well, I don't know that I can usefully comment specifically on allegations 1 and 3 as such, without just making a general remark which would apply to all 3 allegations, particularly the second allegation.
Sorry, the second one's clear. That one, it's 1 and 3 I need a little help with. But
I think there's a lack of clarity there, which leads to some clarity perhaps that you're suffering with 1 and 3.
Very good.
The second allegation pertaining to her testimony before this committee, I believe Commissioner Elliott is quite correct in pointing out that the court had indicated that testimony could not be used by the RCMP for purposes of any investigation, whether criminal or internal disciplinary investigations. However, with the greatest respect to the witness, I think he's taking that decision farther than it ought to be taken, in the sense that, with reference to Superintendent Paulson's report, to the extent that there was an inappropriate attempt by Ms. George to cause Sergeant Frizzell to be removed, and I'm making an assumption here, Mr. Chairman, that would be inappropriate to try to get an investigating officer removed for other reasons. That, I would have thought, a legitimate point of inquiry by the RCMP regarding the internal conduct of both Ms. George or any other officer who might have interfered in an investigation, whether or not it was discussed before this committee. But they can't use the testimony before this committee for purposes of laying any proceedings. But they still could do, as I believe Superintendent Paulson did in his report, investigate into how it was that, or it seemed to be, that Deputy Commissioner George played a role in the removal of Sergeant Frizzell. I'm making an assumption here, and perhaps I shouldn't, that were she to have done so, it would be inappropriate for her to have done so as a matter of police practices, never mind committee testimony. But they can't use committee testimony, and that is what I think the court said. You can't use committee testimony. Now, to the extent that committee testimony touches on points 1 and 3, or 1 and 3 are free of that, they can be investigated by the RCMP for internal purposes. And my concern here, and I don't know, Mr. Christopherson, whether I'm responding to your question. Yep, my concern here is that the court ruling, in my view, be properly understood as to its impact. That is to say, it restricts the use of testimony. It doesn't mean that the same subject matter can't be the subject of inquiry elsewhere. It's just that you can't use a testimony before this committee for purposes of those proceedings.
Chairman?
Yes.
I would like to state that my understanding of the implications of the decision of the federal court and the application of parliamentary privilege is completely in sync with the comments just made by Mr. Walsh, and that the matters referred to in allegations 1 and 3 of the notice of suspension were in fact fully investigated by Chief Superintendent Paulson and others, and that they were the subject of a report to the appropriate officer, and they were the subject of the evaluation and decision by the appropriate officer with respect to not proceeding to adjudication.
And I know I'm running short on time, Chair.
A minute and a half.
Thanks. But that's why I wanted the clarification, because I was having some trouble understanding. And unless the law clerk or you, Chair, want to correct my direction here, it seems to me that we can't have it both ways. We can't tell them on the one hand that you can't use anything that comes up here, and yet at the same time try to take what we're doing here and cross the line into personnel matters within the RCMP, because I just heard from the law clerk that they were able, notwithstanding the Supreme Court ruling, that they were able to go ahead and have independent investigations. Well, what makes those independent investigations of an internal matter any different than any other that's going on at this time, given the number of officers there are? There's likely one or two rattling around out there. So I'm having some trouble understanding where we would hold the Commissioner to account on this reassignment, given that the part of it that is our responsibility has been supported by the courts as being within parliamentary domain and nowhere else, and the separation is clear. And so how can we expect the Commissioner to take account what we're doing at the same time we're saying don't take account of what we're doing? So I'm having a little trouble understanding where we hold the Commissioner to account on this particular order that he has issued.
I'm going to invite another response from the law clerk.
Thank you, Chair.
Mr. Chairman, I can understand the member's confusion because it might be difficult. The subject matter on which someone testifies before a committee is not itself privileged. The testimony given is privileged. Now, all I said a moment ago, or tried to say, was that if the subject matter of Superintendent Paulson's inquiry is the attempt to remove an investigator, that to me is a legitimate, if it's inappropriate, that's an appropriate point of investigation internally with the RCMP. But in doing that, they can't rely on what may have been said or not said here, first point. And secondly, they clearly can't investigate whether a witness was telling the truth or not telling the truth in front of this committee. So in that sense, what is said here is beyond their reach. But the subject matter of the testimony, the issue, if you like, whether it was an inappropriate attempt to remove somebody, is a matter of legitimate concern to the institution itself. And they might well want to investigate it, and could do so in my view, but they couldn't rely on the testimony here or go after her for apparently giving false testimony here.
If you allow me one little bit of latitude, if you can. But so the measures that allegations 1 and 3 that they have the right to follow up on, at that point, that's no longer our business as a committee, correct?
It might be your business. You might choose to make it your business. It's just that, and if you do, the testimony given here is privileged, but the subject matter isn't necessarily removed from the RCMP. They may have their own reasons to look into those other matters. It's just that they can't use the testimony given here for their own purposes.
I understand. I'm just trying to see where there remains a tie-in between our work and the decision of the Commissioner to reassign or not reassign a senior officer based on allegations that are not the direct responsibility of this committee. Because they have their own ownership, and I am done. Thank you.
One last response.
I think the tie-in, Mr. Chairman, is not so much in the substance of the allegations, but in the fact that the committee had not finished its business, and there could well be relevance to the decision of reinstatement, whether the House did or did not find the individual to have been contemptuous of the House. That's not reliance on testimony. That's recognition of a public act by the House of Commons, and it could well be relevant, in my view, to a question of reinstatement. But the Commissioner perhaps made the decision, it would appear, on the basis that the testimony could not be taken into account, therefore it was out of the picture, and the other allegations were withdrawn, so he had no basis to not reinstate.
Okay, Mr. Holland, 5 minutes.
Chair, thank you, Commissioner, for appearing today.
Okay, point of order, Mr.
Mr. Walsh was kind of tried to put some words in the Commissioner's mouth, and I just wanted him to give his opinion that he saw it the same way.
Do you have a comment, Commissioner Elliott?
Well, I think, Mr. Chairman, I've already indicated that I did not believe there was any basis for me to continue the suspension.
Mr. Holland, 5 minutes.
Commissioner, we've just heard from the law clerk that the subject matter is relevant. We know from the Polson report that there were serious questions about Ms. George and in her involvement in this matter. And further, with respect to this committee particularly, we know that parliamentary privilege does not protect a witness from contempt of Parliament or its equivalent term in other processes of perjury. And it most certainly does not protect a witness from lying. And while it may be true, certainly, that the evidence that is given or testimony before this committee is not something that you can use, the outcomes certainly are. And I can say that after the testimony that was given today by Ms. George, that there are deep and troubling concerns about what she said. There are inconsistencies that don't add up, and it stretches all imagination that the truth has been told in certain instances. And so we are left with a very troubling circumstance. And what concerns me, Commissioner, in what you're saying here today in not taking that seriously and not having reserved your judgment until our report both came out, until this committee and the House made a determination about whether or not there was contempt of Parliament, is what is at stake. We know that there is a great deal of public concern for the RCMP right now, that your job is to restore faith in that institution. From the Air India inquiry to Mayor Arar, to the Maythorpe incident, to the tasers, to the pension fiasco that we're investigating today.
We're talking about the reinstatement only. We're not going to get into the Mara.
No, I'm just. This is only contextual to say what's at stake.
But it's getting pretty broad.
Okay. To bring it back, with that as context and that with it at stake, why on earth would you not have waited for this committee, then the House, to make a determination as to whether or not contempt of Parliament occurred before reinstating Ms. George?
Mr. Chairman, I'd like to clarify that I do not believe that I have said or done anything that indicates that I treat the matter of contempt of Parliament lightly. And I'd like to clarify that I do not treat that matter lightly at all. But I do think that it is important for us. I talked earlier about due process. There was a process initiated. That process was based on 3 specific allegations. Decisions were made with respect to those 3 specific allegations. One as a result of parliamentary privilege and the direction of the federal court, and the other 2 based on a careful evaluation of the evidence. That does not, because there's been a determination with respect to a specific process and specific allegations, is not a reflection of the view of me as an individual, or me as the Commissioner of the RCMP, or the RCMP as an organization, with respect to another matter outside of the process that I was called to testify concerning this morning.
But the decision to reinstate Ms. George was made in advance of a report from this committee on the investigation of this pension fiasco. I mean, it just doesn't make any sense to me that you wouldn't wait for this committee's report, a report that was that condemned the actions of Ms. George, found great exception to what occurred there, and yet she was reinstated before that came into place. And that we know that while you can't consider the testimony, it certainly is public. And why would you not have at least waited for the outcome, given a couple of very specific facts? We heard from Ms. George today that it was a shot out of the blue, that she was asked about whether or not she was involved in the removal of this officer. And yet we know from the Polson report that she was specifically advised in advance, and this is on point 9C. She was advised in advance on page 24 that Mr. Frizzell was going to be raised as an issue, and yet she said it was a bolt out of the blue. And then she took the time in her testimony, and I'm just looking for a copy of it here, in her testimony to say, where's the thing that came to me? Here it is. She stated in absolute unequivocal terms that she had, where is it? Oh, here it is. Apologize. I can state with absolute finality, and these aren't equivocating terms,
point of order, Chair,
that she had anything whatsoever. And I realize my point is that these are public proceedings, and that the outcome.
Please, Mr. Polly.
Nothing that Mr. Holland is saying is even admissible with the RCMP. No. None of that testimony is considered, it can even be considered in disciplinary proceedings against any of its employees, because it is entirely immune. And that's not me saying so. It's the Speaker of the House that has written the RCMP to instruct them so much. Chair, so why are we even reading this testimony, which would not have even been admissible in the decision that the RCMP made?
Chair, my point is simple.
Mr. Holland, please. Okay, go ahead.
Thank you. My point is simple, Mr. Chairman, and that is that the outcome is actionable. The subject matter is actionable. And that I am not suggesting that to the Commissioner, I'm not suggesting that you make a determination on what your thought is of this process. But simply, you are aware that there are grave inconsistencies here. And I'm asking why you would simply not wait for the outcome, which is actionable and I would suggest must be actionable. Why would you not wait when there are such serious questions before the House of Commons, before this Parliament?
Mr. Holland, your time's up.
Mr. Chairman, I think that it is my understanding that the matters that the honourable member raises as being actionable, to use his term, are not actionable within the context of the disciplinary process initiated on the 30th of March 2007 by against Deputy Commissioner George by the then Commissioner Beverly Busson.
Thank you very much, Commissioner Elliott. Thank you, Mr. Holland. Mr. Polyev, this will be the last question for 5 minutes.
Commissioner, Mr. Holland went on at some length reading excerpts of testimony before this committee, excerpts that the Parliament of Canada, through its Speaker, have indicated that you cannot take into consideration in your disciplinary proceedings against Ms. George. So what I think you're waiting for is for Parliament to make a decision. We've been advised by our law clerk that the RCMP cannot use any testimony before the committee. However, it can use decisions by Parliament. No such decision has been made. To this point, Ms. George has not been found in contempt of Parliament. If she were to be found in contempt of Parliament, you could consider that as an agency. But as of now, there is no such finding. And is it therefore your understanding that you cannot discipline her for things that she has said in this room as part of proceedings of this parliamentary committee?
That's clearly my understanding.
Not only is it your understanding, it is the instruction.
I don't think it's factually correct that there was nothing that is a matter of public record as an outcome. There was a report by this committee that specifically dealt with it.
Now, this is not a point of order. Please, Mr. Polyev, just continue. You've got 2 or 3.5 minutes left, and we are only talking about the reinstatement only. We're not going to go back in the history of the whole issue. The reinstatement only, please.
And even more narrowly, we're talking about whether or not that reinstatement should have occurred prior to this Parliament's decision on the possibility of contempt by Ms. George. And thus far, the RCMP has no usable evidence that Ms. George has been in contempt of anything.
The state, not your state.
And that's what he has said.
Okay, well, do you have any questions?
The question that I have for him is it the view of the RCMP that allegations 1 and 3 have not been proven?
Yes.
Okay, so the RCMP has determined that allegations 1 and 3 have not been proven. Is left then with allegation 2. Now, allegation 2 is that she perjured herself before this committee, which, even if it were true, and even if one day it is found true, you cannot legally take it into consideration in your proceedings because our Speaker has written you and said you may not. Is that correct?
Yes, just one minor point of clarification. The allegation which we're referring to as 2, which is so numbered in the formal notice of suspension, is based on an allegation of giving false testimony.
That's right. So we have 3 allegations. One is that of an inappropriate conversation Ms. George allegedly had with Mr. McCauley. 3 is that she participated in Mr. Frizzell's removal.
3 actually is that she. This is not the exact language of the allegation. Again, I can.
But more or less, that's.
No, basically, the allegation is that she misled or failed to inform Commissioner Busson.
Okay, so that. But you have dismissed 1 and 3 as allegations. You're left with only allegation 2, which deals specifically with her testimony, her words in this committee. And you have since been written by the Speaker of this House telling you that you may not use her words. Therefore, having dismissed allegations 1 and 3, you're left only with allegation 2, and you've since been told you are not allowed to even consider allegation 2 because it is privileged.
With respect to allegation 2, I agree with the description the honourable member has made. With respect to allegations 1 and 3, just to be technical and precise for a moment, a decision was made not to proceed to adjudication, which I think is somewhat different. It has the same effect, but dismissal sort of sounds like there was a formal adjudication and a dismissal. But what happened was those responsible for presenting the case to a board determined that there was insufficient evidence to proceed.
Just to conclude, through the use of deductive reasoning, we have 3 allegations. You've decided not to pursue the first and the third. The second involves testimony before a parliamentary committee, which you are not allowed to use in your proceedings, according to our own Speaker in a letter to you, and therefore the responsibility rests with us to determine whether or not she is in contempt. It is the responsibility of parliamentarians now to do our job in determining her comportment before this committee, and that it is beyond the scope of the law for you to make that determination for us. Is that your understanding?
That's my understanding.
Thank you.
Okay, thank you very much, Mr. Polyev. What time is it, Justin?
It's 10:37.
It's 10:37. The law clerk has Mr. Sweet.
If I could ask the indulgence of the committee, a number of things were thrown around there, 1 and 2 and 3, and there's one fact that we didn't get on the record, and I don't want to ask a question, but I would ask if you would confirm it. That for 1 and 3, was it the sole discretion of Deputy Commissioner Sweeney to make the decision that the 1 and 3 were not actionable?
Okay, you heard the question. Perhaps I'm going to ask the member to repeat the question to the Commissioner.
Commissioner Elliott, was it the sole discretion of Deputy Commissioner Sweeney, after Paulson had tabled his report, not to action 1 and 3?
Yes, but just to clarify that after the report was provided to Deputy Commissioner Sweeney, as I indicated in my opening comments, he made a number of further inquiries. Those included further discussions with Chief Superintendent Paulson, discussions with former Commissioner Busson, the seeking and receipt of legal advice, and then he determined, as the appropriate officer, not to proceed to adjudication.
Okay.
Question. You don't think it is, Chair? It won't go.
Go ahead.
But I would like to know, for the purposes,
your judgment.
Yeah, for the purposes of what we're looking at here, if there was any senior officer, not just this, I'm asking now hypothetically, but if there was a finding of contempt by the House, would the Commissioner then have the right to take that decision and do something in terms of the officer now has done something
that would be highly speculative.
Well, it's speculative, Chair, to the point that we called him in here because we're saying that he shouldn't have.
We'll let the Commissioner respond.
He shouldn't have done the appointment, and so I think it's fair to say, to get a picture in our minds, because we're not a legal body, what would have happened in the full extent to get a sense of how much traction this issue has. So, if you would, Law Clerk.
Well, I'm going to ask the Commissioner, do you have any comment on that point? Then we'll...
Well, I think my 2 comments are that the matter is A, speculative, and B, it would be complicated by the fact that all of the documents I referred to, including or that have been referred to, including correspondence with the Speaker and the Chair of this committee and the federal court, talk about the fact that it's not only the sole purview of Parliament to investigate such matters, but also to punish them. All I can say is that if future events arise, we would certainly look at them and see whether further action was warranted.
Chair, I just want to state for the record that what the Commissioner has just indicated is not the opinion of the clerk, is the unanimous opinion of the House of Commons.
We'll have a chance to discuss this after, Mr. Polly. We're not getting into a debate or argument right now. I'm going to ask the law clerk, he's got a point to raise. You don't have anything? Okay.
It was covered by the...
Okay, as everyone knows, this committee will discuss this in camera at a later date, and the room is starting to fill up. I'm suspicious that they're not all here to watch us. So what I'm going to do, I'm going to adjourn now, and I want to, on behalf of each member of the committee, Commissioner Elliott, I want to thank you for your attendance here today. You were very helpful, and this matter it's somewhat troubling to the committee, and I'm sure it's been challenging to yourself too. But again, we want to thank you very much for coming today under reasonably short notice, and we certainly appreciate your assistance. So, okay, meeting adjourned.